dedicate this video to John Morozin. He was my friend and a police officer who dedicated his life to protecting people, and he helped to create this channel, the Police Roll Call channel. I am Stanley Cohen. I'm an attorney at law, a former Cincinnati, Ohio police officer, a former professor of law at Indiana University of Pennsylvania in Indiana, PA. The goal of this channel is to explain appeal court decisions to help police officers enforce the law on the street, but more importantly, to enable them to defeat defense attorney motions to suppress evidence and defense attorney motions to dismiss charges, and in general to help citizens everywhere understand their rights under the Constitution. Now, the court decision I'm going to talk about today is Commonwealth of Pennsylvania versus Davenport, decided by the Superior Court of Pennsylvania in July of 2024. Police officers in the United States may cite this decision if it will help them win their case in court, and if the facts in the officer's case are sufficiently similar to the facts in the court decision, and if the court's decision is sound and reasonable, which I believe it is. Now, the facts of this case are as follows. Two police officers stopped defendant Davenport's car for traffic violations. When one officer went up to the window to get the papers, he saw a gun on the front seat of the car, and he interpreted this situation as a danger to himself, an immediate danger to himself. A question of law to answer is this: does the officer have authority to enter the car right away, to seize the gun, without asking the driver for a consent, and without asking the driver if he has a license to carry the gun? By the time I finish explaining this decision, you will know the answer to these questions. Okay, so what the officer did was he entered the car immediately, he seized the gun, and then he asked Davenport, "Do you have a license to carry the gun?" When Davenport answered the question, no, the officer arrested him for that crime. Now, in court, Davenport's attorney made a motion to suppress the gun on the ground that the officer's entry into the car was illegal because he didn't have a consent, he didn't have a search warrant. The trial court denied the motion, and the defendant was convicted. He appealed. Now, in the appeal court, the appeal court cited the Fourth Amendment in its reasoning, and the Fourth Amendment states that all persons shall be secure in their right to be free from unreasonable searches and seizures of their persons, homes, papers, and personal effects. So the court applied this amendment to the facts in the following way to support its decision to support the denial of the motion to suppress. They reasoned that when the officer saw the gun on the front seat of the car, this presented an immediate, imminent danger to the officer's life, because Davenport could have grabbed the gun in a split second and fired it at the officers. So the court concluded on that reasoning that the search, going into the car without a search warrant, without asking the defendant for a consent first, without checking to see if the defendant had a license to carry the gun first, was reasonable under the Fourth Amendment. And so it is proper, the court concluded, to support the trial court's denial of the motion to suppress. And that pretty much wraps up this court decision. And if you would like to watch further videos like this in the future, please subscribe below.